Okay. Hello, my name is Krista Hermance, and I am an estate planning attorney. Today, we're going to be talking about estate planning for mom and dad. Um, so, our firm is Hermance Law, where we are the estate planning mom and dad, and we really just focus on working with families to make sure that people have legal documents in place to make sure that their family is protected and that whatever legal wishes they have are very clearly documented. Um, these are our attorneys that we have at our firm. We have offices, I'm sorry, our team, it's very family oriented. So it's really about making sure that we have that balance of being able to service clients while also having time for families. We have offices in Ventura, Westlake Village, Santa Clarita, Calabasas, Irvine, Pasadena, as well as virtually throughout the state of California. It's all over the state. If they are in the state of California, then we can assist. Okay, so let's get to it. I do want to be mindful of your time. I'm going to keep this to 30 minutes. I will save some time at the end to be able to answer any questions that you may have. Okay, so what happens when someone doesn't have legal plans in place? And so we're really focusing on estate planning for mom and dad today. And the idea is that maybe you've had conversations with your parents and they don't have any type of legal documents in place, or they've put the conversation to the side. They don't want to talk about it. They don't want to worry about it. I see a lot of different types of things happening when these conversations come up. And I feel like if they had a little bit more information about what could happen without having legal documents in place, it might make them more susceptible to actually doing the planning. Okay, so what happens when there are no legal documents in place? Well, we look at two different sides. We look at one being incapacity. So incapacity is when somebody doesn't have the mental ability to understand what is going on. They don't have the ability to make decisions on their behalf, to understand what the ramifications would be for making decisions. And that's really what we're talking about when we look at incapacity. So in the state of California, which is where I'm licensed to practice, if you are not in California, this information may be information for you, but it's always best to work with an attorney in your state. So this is specific to California. So in California, we have what's called a conservatorship. So that is a court proceeding that's done through our court process where someone is appointed by the court to act as a conservator for the person that needs that assistance. They would be then able to manage financial aspects of day to day, as well as personal care. So healthcare decisions, anything relating to decisions that they are unable to make on their own, the court is appointing somebody to be able to make those decisions on their behalf. The cons of having a conservatorship, one is that you have a court that would be deciding who the conservatorship would be. Who would be that conservator. And so it may not be who you would actually want to act in that role. It's the court deciding, because at this point you have no legal documentation saying who you would want to be in this role. And so this is the court saying this is who would be conservator for you. The other thing is it is a completely public process. And so that whole proceeding is going to be out there for people to be able to know what any information about you, information about your assets, debts, stuff that generally you might want to keep private would be out there for public viewing. The other thing is conservatorships are very, very expensive. Just the amount of work from an attorney perspective that goes into it, it's very costly. And this is all stuff that can be prevented by having proper estate planning documents in place. Okay, so the other side that we look at is that if there is no planning documents in place, when somebody passes away, there is what's called a probate proceeding, and that is where your assets that you own in your name individually would go through this probate court process. In California, it would be required for any estates that are over $166,250. And so then it would be required. So if you own a home, right? And when I say own, it's not that you own it outright, you don't have a mortgage, it's just you have a house in your name. Generally, it's going to be over that threshold that it would have to go through probate. So reasons to avoid probate, again, these are the big ones that if you have family members with mom and dad maybe not wanting to do this, these are important things that you can go through with them so that they understand. So one is probate court is a very long process. In general, it can take 1 to 2 years, and that's from the start of the probate proceeding to the end. And that's uncontested. That means that family is getting along. It's just the amount of time it takes to get through that process. The other thing is it's public. Anybody can go to the courthouse, pull the records, find out what you own, who you owe money to, and who your beneficiaries are. It's also very expensive. Probate court in California is set by statute. And so just to give you an idea, and this is where I think a lot of people don't understand how expensive probate court is. And they say, oh, I don't need any planning. But if they understood how much money would have to go to pay for probate to go through this process, they might be more willing to go through the planning part of it. So let's say you have a gross estate where you have a home with a fair market value of $490,000 and $10,000 in various bank account savings, investment, things like that. So a total probate estate of $500,000. Again, it doesn't matter how much equity you have in the house, it's what the fair market value of the house is. So $500,000 would give you statutory fees for attorneys and personal representatives of $26,000, and then costs on top of it. So how much it costs to file the probate petition, the final probate petition cost, probate referee fees, bond fees, publication fees. So all of these fees associated with it costs the estate money. And $2,000, that's on the low side. So you're looking at about $28,000 for a $500,000 estate to go through probate. And that's money that just comes directly from the beneficiaries. Okay. One thing that I think is a really great resource, I hadn't planned on sharing, but I do want to put this up here, is if you go on our website, it's hermanslaw.com, and I'll include the link in the email that I send out. If you go to resources and go to probate fee calculator, you can show your family members how much it would cost to go through probate. And so let's just say even if you just take a house, let's say you have a house with a fair market value of $800,000, and you go through and you look at this bottom, it's going to tell you exactly how much it's going to cost to go through probate. So an $800,000 house that would have to go through probate would be $38,000 in attorney's fees and personal representative fees. Okay, so this is a really great way to show them this is what the state statute says is how much it's going to cost. Okay, and this can be avoided with proper estate planning. Okay, so planning documents and organizing. What are the important documents that you can do with that to have your parents do, or that you should do to make sure that you have these legal documents in place? Well, we have a power of attorney, advanced healthcare directive, and HIPAA authorization. We have a will, a revocable living trust, and then really just organizing any important paperwork and checking beneficiary documentation on any accounts that you currently have. These are all things that you can do to start getting things really organized, right? Making sure that you have all of these specific things done. So these are the things that we're going to be going through today. One thing that I think is important to consider is just from a planning perspective, what that timeline looks like. So planning, the best time to plan is when you are in this pre-planning stage. And this can be if you have elderly parents, as long as they have capacity, they understand what's going on, and they have the mental ability to know, yes, these are my assets, these are my kids, there's no question about them lacking the capacity. This pre-planning is a state that they would be in. And this is really the best time to plan, because this is when we can do everything in the state of wellness, where there's not these emergency procedures that are being done, where we don't have to go to court to do it. Because if there's some type of incapacitating event, like a stroke, a heart attack, something that would give them where they wouldn't have the capacity to make these decisions, then you get into this crisis planning stage. This crisis planning stage is really then when it goes into that conservatorship side, when the person doesn't have the capacity to make decisions to be able to get these legal documents in place. And that's where things get a lot more expensive. They take a long time, and they're the public, where it's out in the public, because it has to go through court. Okay. Okay, so first thing we're going to talk about is the power of attorney. So, what is the power of attorney? Well, it's basically just a document where you identify an agent to be able to make financial decisions on your behalf if you were unable to do so. So, financial decisions relating to banking stuff, tax returns, going to the post office. If you're in the middle of selling a home, life insurance, all of these kind of financial decisions, you're basically giving your agent the ability to step into your shoes to make financial decisions on your behalf if you are unable to do so. So when you have a power of attorney document, you get to pick the person that you would want managing if you were incapacitated, where this is different from the conservatorship where the court's choosing. This is your ability to choose this before it would even have to go to court because you have identified who you want this person to be. And so when you do a power of attorney, you don't lose any rights. So long as you have capacity and you're able to make your own decisions, your agent can't overrule what you want. California, we have the option to do what's called a springing power of attorney. And so what that does is it allows you to say, well, I wouldn't want this power of attorney document to be effective until I was incapacitated. And so it's only once that event happened that then this person can make financial decisions on my behalf. It's important when you are doing a power of attorney document, you identify a primary agent and then you have backups as well. So that if that primary person couldn't act on your behalf, you have somebody that you've identified to act as the backup. Okay. If at any point you have any questions, please feel free to put those questions in the chat or answer in questions box, and I will get to those either through the presentation or again, I'll save time at the end. Okay, the next document, the Advanced Healthcare Directive. So this is such an important document, very similar to the power of attorney, but this allows you to identify an agent to be able to make healthcare decisions on your behalf if you were unable to do so. And so, if you didn't have the capacity to say what you would want, this is the person you've identified to be able to make those decisions on your behalf. The very famous case where this document comes into play is the Terri Schiavo case. Terri Schiavo was 26. She was married. She had a stroke in her home in Florida. They tried for a few weeks to revive her and get her to a better place. And at that point, she was in a persistent vegetative state. So she didn't really have any idea of what was going on around her. She had machines basically keeping her alive in that persistent vegetative state. Her husband at the time wanted to take her off of life support. Her parents did not. And so then what ensued was 15 years of legal battles that were very, again, highly publicized. It went to the Pope, it went to the president. And in the end, the husband did end up prevailing. He took her off of life support and she passed away shortly thereafter. Had she had some type of documentation that said what her wishes were, this could have been prevented, but she was young, right? When you're young, you don't think you need these documents. But that's why these documents are so important, because then it makes sure that the people that are making decisions for you know what you want, that healthcare providers know what your choices are. The Advanced Healthcare Directive is also known as a living will. Some people will refer to it as that. In your Advanced Healthcare Directive, you choose certain end-of-life decisions also in there. So in addition to choosing who you would want making decisions for you, you can also say, do you want to be buried? Do you want cremation? Do you want to do any type of organ donation for transplant purposes, or no organ donation at all? Did you want to do any type of medical research or any organ donations for medical research? Would you want extreme measures with prolonged life support to keep you alive, or would you want to be taken off? So these are all things that you get to choose in that Advanced Healthcare Directive. Another important medical document that provides protected information to people that you would want to be able to receive it is the HIPAA authorization. And so this allows you to say, here's people that I would want to be able to talk to doctors, get medical records, and find out what was going on. It's important in your Advanced Healthcare Directive that while you identify an agent to be able to make those decisions, you also have backup agents as well. Okay. Next is the will. This is probably the most common estate planning document when it comes to estate planning. So what is it? Well, it is a legal document where you give instructions to be carried out after you pass away. In your will, you say how you want your stuff distributed. Where do you want your money and your assets to go? If you have minor children, it allows you to nominate guardians for your minor children. In a will, minor children, depending on how the will is structured, would get money when they turn 18. When somebody passes away, their will is filed with the probate court, which therefore then makes it a public document. If somebody does not have a will at their passing, their estate is distributed according to California law. We call this intestate law. And it's basically just California's way of saying, if you don't have an estate plan in place, here's the one that we have for you. The problem with that is that it may not be how you would want your stuff distributed. One of the biggest myths I hear surrounding wills is that having a will avoids probate court. And this is just not true, right? All a will does is it tells the court, here's how I want my stuff distributed. So it guarantees probate court. Okay. It's one of the biggest misconceptions I have. And it's also one of the things that I hear from clients when they talk to their parents about estate planning and they ask their parents and their parents say, oh yeah, I have a will, it's all taken care of. But a will doesn't avoid probate court. And that's really where that distinction come in, is they think that, oh, I have a will, that's all I need. But how do you know that's all you need? If you just think a will is all you need, that doesn't actually mean that's all you need. So that's why it's important to understand that there's other things that can be done, because all a will is going to do is it's going to say, here's how your stuff goes through probate. Okay. And it's very important, because I know it's hard to have these conversations, especially with elderly parents. If they don't want to talk about it, or maybe they're very private. I see that sometimes too, is where they don't want to discuss finances. They don't want to discuss any of this stuff. And so they just, say, oh, I already have that taken care of. But what do they have taken care of? And it's really trying to, as much as you can, figure that part out. Okay. Okay, the next document is the revocable living trust. And in California, probate court is not a process that a lot of people want to have to go through. And so we use revocable living trust in almost all of our planning, because it is what avoids probate court. So what is it? Well, it's basically just an agreement between the grantor, which is the creator of the trust, where they put specific instructions in writing to the trustee, which is the person who agrees to hold legal title to all of the assets in the trust. And they do this for the benefits of the beneficiaries. So 3 kind of big terms I throw at you: grantor, trustee, and beneficiary. When you have a revocable living trust and you create it, you are all 3 of these roles. So you are the grantor, meaning you're creating your trust. You are the trustee, meaning you are in charge over all of the assets in your trust. And you are also the beneficiary. So all of the assets that are in your trust are there for your benefit. You're not losing any control when you have a revocable living trust. You still have complete access to all of your stuff. Generally, when you have a trust, there is no court interaction. That is one of the big draws of having a trust. And one of the big benefits is it keeps things private. It keeps it out of court. So one myth I hear about trust is that trusts are just for wealthy people. Well, I disagree. I don't think you need Bill Gates to be at Bill Gates' level to have a trust, because if you remember our website that I showed you, that showed you the probate fee calculator. Well, if you had a trust, that $800,000 house that would have to go through probate to be able to be distributed to your beneficiaries, that cost, I think it was $38,000 in probate fees, could be avoided by having a trust. And so I think just average people that have these assets, they own their own home, would benefit from having a trust. And I don't feel like a lot of people really understand that, right? There's a lot of cost savings that could happen by having a trust. And you don't have to be wealthy to be able to get that. Okay, so some of the benefits of having a trust is, like I said, it's private, right? There's no court involvement, because generally that's the idea of the trust, is to avoid probate court, which saves that time, that 1 to 2 years of going through probate court, and money. Right. So not having to pay those high probate fees that would go through, that are those statutory fees. Other benefits of having a trust is it allows you to set up sub-trusts for your kids. So, if there's, depending on what ages your children are, even if they're adults, you could say, well, you would want the money to be distributed to them at ages rather than outright distributions. This is common if you have some adult kids that maybe wouldn't do well receiving an outright distribution, right? If they got a lump sum of money of $100,000, would you want them to get all of that money at one time, or would you want it to be protected for them? And so that's what a trust could do, is it could either distribute it outright or keep it in a protected trust for them. So A trust can protect your children's inheritance from predators, creditors, and divorce. Um, when you have a trust, you get to choose the trustee that you would want managing your finances for your children. So if you have adult children, managing it for them. In addition, you could have your kids be the trustee. If you have adult children that are responsible and are going to help you and take care of stuff, you could have them be it. I've also seen grandkids, right? If you have adult grandchildren that are responsible and you would want to be able to follow the terms of your trust, you could name them as a trustee. They just need to be over 18. Another thing too is you can use the trust to list it as a beneficiary on accounts so the funds don't have to go to kids. So again, if you have a child that maybe has a gambling problem or a drug problem, or if you have minor kids and you wouldn't want them to receive that money, you could have it where the beneficiary would be set up as the trust rather than going to kids directly. Okay. Going through important documents that you have is so important. We don't just handle estate planning, right? We handle after somebody passes. So we handle the probate process and we also handle trust administration. And this is one of the things that I see time after time after time is when somebody passes away, somebody having to go through all of the documentation, right? To figure out what assets there are, life insurance policies, retirement accounts. And so being able to organize, I know that would be amazing if people could organize their documents, but it's just something that kind of just gets pushed off. I get it. It's busy, but it's important. So being able to go through your documents and just locate all the account records, printing out statements. And I don't mean go back and print statements for the last 10 years. That's not what I'm talking about. But at least having one statement or some type of record from every different type of account that you have, checking accounts, savings accounts, retirement, pension, investments, stocks, bonds, any different account any type of account that you have, having at least one printout from every one of those and having it in one place. Like we have this estate planning binder or a portfolio that we give to our clients so that they can keep all of this stuff in here. And by having all of that stuff just organized in one place makes it so much easier that if something happened, your emergency person, I call them your VIPs, would be able to go in and just know, here's all the stuff that you have. And they don't have to go searching through mounds and mounds of paperwork trying to figure out, because that's how life insurance policies get lost, right? If you can't find any record of it, somebody might not know it exists. So that's why it's so important. So locating life insurance information, printing those policy pages and putting it in your stack of important paperwork, like in your binder with all of your estate planning documents, is important. You also need to make sure that whoever you choose to act as, depending on the type of estate planning documents you have, it might be an executor or successor trustee. Again, I just call them your VIPs. So it's important that your VIPs know where to find these documents, right? If you go through all of this work, it's important that they know where to access them, right? Where are they at in your house if they're in your house, or where are you keeping them? That's important. The other really important thing that just, it gets missed is checking any beneficiary designations you have for accounts. So it could be life insurance policies, it could be retirement accounts, even bank accounts. I see sometimes what are called pay on death benefits. So you want to make sure that you go through and you check all of these beneficiary designations to update it to who you would want those beneficiaries to be, whether it's people that you have identified or you have a trust. You want to make sure that you update it accordingly. I just had a meeting this morning with a client and we were talking about, just wrapping up their estate plan and we're going through all their accounts. And I said, do you have life insurance? And they said, yes. And I said, who's the life insurance beneficiary? And the response was my husband that passed away about 5 years ago. So it had never been updated to her kids. And so that is the perfect example of why it's so important to make sure that you have those beneficiary designations updated. The other really important thing is property deeds. And so it's important to see how title is held when it comes to your home, right? Is it And I mean, I see this a lot where I have a client that'll come in and they were married, their spouse passed away, but the spouse is still listed on the deed for the house. And so there's stuff and work that needs to be done in fixing that. And I know it happens a lot and things don't get fixed, but when issues arise are when somebody goes to try and sell the house. And that's where title issues can happen. And so these are all things that knowing how property deeds, how things are held for property perspective are really important, because you also want to make sure, how is it held, right? Is it, this person and this person as joint tenants with right of survivorship? Is it husband and wife as community property? Is it tenants in common? There's all these different ways. And that's why I think working with an estate planning attorney is so important, because then you can understand what that actually means. You can understand what the effect of that could be, because I see it in probate court all of the time when probably what their intentions weren't actually what happened. And now their family is in they're having a lot of problems, right? When it comes to distributions. Okay. So who needs planning documents? So anyone over the age of 18, but especially if you own a home. That is the biggest thing that I see is people that come to me, all they have is a home that's left. Everything else has been distributed through beneficiary designations, but there's still this house that was, owned by mom and she passed away and it needs to go to her 2 kids and it has to go through probate court to be able to get to them, right? That could be prevented by having proper estate planning documents in place. So if you need help, if your parents need help, you need to start that conversation. You can schedule a free 30-minute telephone consultation with us to be able to really just understand what needs to be done. I'm going to post the link here in the chat for you. I'm also going to put it in the email that I'm going to send out. You can go to our website and book that free consultation to just get an idea of why it's so important, specific to your situation, and how it's going to help. Okay. Okay, at this point, I will save time for any questions that have come in. If I don't see any questions, I do have a couple of things that I thought I would address that came up to me after I had already done putting together this presentation, but I thought was important. So I will give it a few minutes for any questions to come in. And while I'm waiting for that, if you have any, just a couple of things to consider of issues that I've seen, I think would be important to share. So one is not doing any planning at all. And maybe from a family dynamics perspective, a parent will have kids, maybe some from a blended family, or maybe you'll have a child that has basically you haven't seen in 40 years, which I have actually several cases that have had this happen. And if there's no planning documents in place, then when the parent passes away and the estate's going through probate and it's going to the beneficiary or to the heirs because there's no planning documents, well, that one child that hasn't seen the parent in 40 years is still an heir. And so they're entitled to their share of the estate. And so a way that would prevent this is by doing planning documents, caring for that heir that they are not to be cared for in your plan so that they wouldn't receive it. Okay, so that's one thing. A second thing I've seen is parents that don't want to do any estate planning. So they say, well, I just want to sell my house, so I don't have to worry about it, right? I don't want anything to have to go through probate because it's going to be too expensive. Well, if you sell a house that you've had for, let's say, 20 or 30 years, the amount of money that you're going to pay in taxes from the capital gains is going to be very high, right? And it may be higher than you just keeping the property and distributing it to your kids, where they wouldn't have to pay those capital gains taxes that you're passing, right? They would get what's called a step up in basis, where that property would pass to them at that new basis at the date of your passing. And so it's important to understand that, while it seems like estate planning may be expensive, the cost of income taxes you're going to pay from selling that property could be very high. Okay. Okay, question that came in. Do mom and dad both need individual trust? Is there a family trust for properties? So it really depends on what assets are owned. Are they owned as community property or are they owned as separate property? I've seen all different ways of doing it. The most common way is that we'll have a joint trust for mom and dad. They own property together, and the trust just works for both of them. Generally, if they have separate property and they want to keep it separate, then we would do a separate trust. So it really depends on the family dynamics, as well as what assets they own. Okay, one other thing that I thought about that I've seen being an issue, and people just tend to do this, is they'll just add one of their kids to their deed, right? Or to bank accounts, or to things, so that it avoids probate court, because it would just pass to that kid. Well, if you have multiple kids, then all of the stuff is passing to one kid. They don't have any reason that would force them to give the money to the other kids, right? To share, because it just goes to them by operation of law. The other thing is, if you add your kid to the deed, there could be issues with reassessment. There also could be, if that kid has trouble, right? If there's creditor issues, they get sued, then they put a lien on the house, right? Because they're on title for the house. And so there's all these issues that can occur by just saying, well, I just want to add my kid to my house, or I just want to give my kid my house, right? There's consequences that could come up. Whereas estate planning, while it costs money, it's the consequences that could happen by trying to not do estate planning could be so much more substantial from a cost perspective. And so it's just all kind of things to keep in mind. Okay. I want to finish up and be mindful of your time. So thank you so much for joining me today. Again, if you have any questions, you need to get estate planning done for mom and dad. We work with all ages to try and make it easy for them. We'll do what we need to do to make it so that they can get their planning done. As long as they're in the state of California, then we can assist them. So please schedule a free 30-minute phone consultation. And thank you so much for joining me today. Have a wonderful day.